The core issue in McCoy versus Louisiana is the question of whether it violates a client's Sixth Amendment right to counsel to admit a client's guilt at trial. Robert McCoy was charged with the triple homicide of family members of his estranged wife. And from the moment he was arrested, he insisted that he was innocent, adamantly. Mr. McCoy did plead not guilty. Robert McCoy was originally assigned a public defender, and ultimately that relationship with the public defender deteriorated, and Mr. McCoy hoped to represent himself. Ultimately, his parents retained a private attorney, Larry English, who was hired and paid by his family to represent him at trial. At trial, it was Mr. McCoy's defense attorney's strategy to try to convince the jury that Mr. McCoy was actually not competent, despite the fact that the evaluation had found otherwise. Mr. McCoy asked his attorney on multiple occasions to tell the jury that he was innocent, but Mr. English, his attorney, did not do so. His hope was that Mr. McCoy would ultimately be sentenced to life in jail instead of the death penalty, but unfortunately Mr. English's strategy backfired, and Mr. McCoy was sentenced to death. This case made it to the Supreme Court, and the Supreme Court ultimately decided to take the case because there was disagreement between state courts of last resort as to whether it was a violation of a client's Sixth Amendment right to counsel to concede the client's guilt over the client's objection. At oral argument, Mr. McCoy's new attorney, Seth Waxman, argued that English's behavior during trial was essentially a structural error, meaning that the trial was so fundamentally flawed on a foundational level that the entire conviction had to be thrown out and that Mr. McCoy deserved a new trial. He argued that Larry English's decision to concede his guilt at trial was not only ineffective assistance of counsel, it was essentially the deprivation of the Sixth Amendment right to the assistance of counsel. So the client should have the opportunity to ask the attorney for their advice, but not have to follow it. Louisiana was arguing for a more narrow holding, saying that this was essentially ineffective assistance of counsel, but that Mr. McCoy had not been deprived of his Sixth Amendment right to counsel. In a 6-3 decision written by Justice Ruth Bader Ginsburg, the Supreme Court found in favor of Mr. McCoy, finding that it was in fact a violation of his Sixth Amendment right to counsel for Mr. English to tell the jury that Mr. McCoy was guilty over Mr. McCoy's adamant objection. Justice Sotomayor said, "People have the right to walk themselves into jail. Everyone has the right to represent themselves at a criminal trial. And if they consider the attorney that they have to be a burden, then they don't have to accept them and they have the opportunity to represent themselves." 3 dissenting justices, Alito, Thomas, and Gorsuch, find that the majority made a mistake in their holding. Justice Alito appears to be advocating somewhat for Larry English, saying that it was not that he conceded the client's guilt, it was that he was really arguing for a lesser conviction on behalf of Mr. McCoy. Justice Alito also writes that he believes the majority opinion is overly broad, in that he finds that this is a rare case that is unlikely to be replicated.